right, let's see. We hit the Let's Go Live button. Might be a second early. All right, looks like we're up and running. Good morning, good morning. All right, so we got a lot to cover today. Let's see. So we are going through. So previously, the Olsons had filed a filing to dismiss, and so basically they were trying to get the case dismissed early because there wasn't quite enough evidence yet. We talked a little bit about that in the temporary restraining order, and so the temporary restraining order obviously was declined, and it was because they didn't feel like they had enough information to be able to do the temporary restraining order for Eric Olson. So shortly after that, they filed a motion to dismiss, which would basically be a shorter court hearing where basically they would just come in and decide whether to get rid of the case altogether. So we're going to go through that particular filing and then the judge's motion on that. But I think we need to do a little bit of a recap. I'm getting a lot of questions about like where we are now. It's been so much information that's kind of been dumped out. So let's go through a little bit of that. So because we're getting into this point where it's going to be a little bit more of a volleyball back and forth, whereas in the beginning everybody's just kind of throwing stuff out there, and then now we're kind of in this thing where one will file and then the other one will do it, and we'll kind of start getting back into that oscillation. So this first oscillation really is going to be all mostly WFG's side. So let's kind of recap that, and then we're in this position where the Olsons and GFI are going to be coming back to kind of counter that. But this was an important one to kind of quash this dismissal. So now that that's kind of been wrapped up, but we want to see what's in it. So we'll go through that. So let's kind of recap a little bit on the discovery and what's happened thus far. So previously, if you guys remember, WFG has been asking for more information, so they asked for discovery. That did get approved. It was the same motion for the temporary restraining order. Temporary restraining order got denied, the discovery got approved. And so the things that they're looking for are going to be in these particular areas. And we kind of ran through this. You can see this at full length if you want. I believe that was the last video. But what they're doing is now WFG has to start getting evidence on their side, because a lot of it was hearsay, some of the things that they thought were happening, and they need to actually figure out what's going on and the depth of it. And so the judge said that they can start getting information from them, and so now they're going to start their discovery process, which basically allows them to find out what's been going on the inside. And so what they did was they have 4 interrogatories to propound on the defendants Eric Olson and Sandra Olson. They also sent out 4 requests for production of documents. So all of this stuff is what's happening right now kind of behind the scenes. They sent deposition notices to serve defendants and their individual depositions. They also sent out third-party subpoenas, meaning they want additional information from these particular people. It's going to be around GFI. We'll go through that. Manuel Valle, thank you for the gentleman who corrected me on that. And then Hillary Aza. And we'll kind of look at both of those really quick so you can see what's in those. But this is what's happening behind the scenes right now. So it's a little bit quiet, but it's not because nothing's happening. It's just they've got to discover these things first. So let's look at the interrogatories. And so this is basically what they're requesting, the information that they want. So they want to identify all current and former insurance agents, including the date when they first became insurance agents of GFI. And remember, they're looking for causation of, are they anchoring in at WFG, collecting a paycheck, getting insider information, figuring out who on their team they're going to target, while they're simultaneous or spouses with GFI. So they're trying to check the dates on those 2 things to see if anybody else breached their contracts. They also want to identify all confidential information or proprietary property that you or your persons affiliated with you have retained from your departure from WFG. Identify any persons with whom you have shared any such confidential information. So if you remember, one of the gentlemen, I can't remember his name off the top of my head, but he basically hired somebody or wanted to hire somebody to download all of the client information. So apparently there's some way that you can go into, I don't know if it's WFG system or some way to do that, but you can find out all of the client information And as people were moving over to GFI, they were asking them to, I don't know if it was a software they were using, but this person was supposed to go in there and help them download all of their client information so that way when they moved over to GFI, they could go back and solicit all of those. Because once you do your resignation with WFG, you lose your information on that side. So the question is that confidential information? And so they're requesting all of that as well. They want to identify any communications and statements made by you or persons affiliated by you or GFI concerning WFG, its future ability to stay in business, its compensation structure, and its opportunities. So did you say anything derogatory in your process of moving over to GFI? Were you saying that WFG wasn't going to be in business anymore and they were falling apart and all the leadership was going? That kind of stuff, did you take that with you? Also, did you identify any customers with whom you previously worked while engaged with WFG, or whom you or anyone of your downline have communications with since you left WFG? And state the nature and content of each of those communications. So were you going back and talking to your old clients? This keeps becoming the question of churning. A lot of the GFI agents have gone into the comments and said that they're not churning, but we'll find out through discovery if they actually were or not. So that one's kind of a question mark, but it's a good thing to look at either way to see what was happening there. Okay, so those are the interrogatories. Then, if you remember, the 4 requests for production. So this is the information that they want, the production that they want. It's all the documentation and communications relating to or evidence with the creation of GFI. Because remember, it was from Wyoming. So they have really no way to know who's backing it. There was different thoughts about who is providing the money. Some people were saying some other venture capital companies. We don't really know. So they want the documentation and the communication relating to the evidence of the creation of GFI, its contract or agreement, and its registration. All documents, communication using your confidential information, proprietary information, similar to kind of what we saw before. Any communications or statements you made or caused to be made about WFG, its compensation, its business practices, its financial liability, its opportunity, its leadership, or its independent contractors. And they also want all documentations, communications reflecting your evidence, your persons or behalf of you communicating with WFG insurance agents, their spouses, their family members concerning GFI, or possibly becoming affiliated or part of GFI. And this is what we looked at last time. Cofield had a long string of messages, basically that somebody copied from their text group, which to me clearly showed, I don't know your guys' thoughts on that, but it looked like they moved a bunch of WFG agents into this group chat, ran a group meeting for WFG agents, and then all of a sudden they're fired up and ready to go for GFI, and they're mad at WFG. So obviously whatever was said in there. So were there presentations done with WFG agents to kind of convert them over? And there's questions on that. A lot of you guys have said into the comment, well, aren't they kind of your agents? Yeah, that gets into this weird ground of like, what ownership do you actually have? Do you own the agents that are there? Because they have choices too, right? They're able to stay or go or do whatever they want. And so it kind of opens up some interesting dialogue as far as that goes. Okay, and then request for production. They're also doing asking for additional information around GFI and some of those things as well. And so you can see that whole discovery aspect is what's going on right now. Then they submitted the subpoenas. So they're subpoenaing GFI, they're subpoenaing Manuel Valle and Hillary Azaz. So all of this stuff is happening behind the scenes right now. And then the last one we covered was the updated amendment to the original lawsuit that WFG had with Eric Olson. And in that, they added a couple more people. So these people are getting summons. So they need additional information from them as well. So the other people that have been added to this, so they still have a bunch of people that they don't know. They assume maybe up to another 47 of them that they don't know right now. But the 3 that were added is going to be Chernowski, Carter, and Cofield. And those, we did a deep dive on that one last time. And so basically they've got testimony from other people, their transactions, their termination letters, we went through all of that they're adding them to this lawsuit as well. And so they recently summoned them. So this is going to be Eric Carter's summon, then Cherwinowski's summon, and also Cofield's somebody corrected me on his name as well. Thank you. I appreciate you guys. So that kind of gets us up to date. And all of that is happening behind the scenes. So as you can see, WFG is on this huge motion for discovery. They're just trying to figure out what's going on. So they're talking to all these individual people. So it's kind of quiet right now because they're working in the background. Now, simultaneously to that, the Olsons had filed to get this all dismissed. And I think really the reason for that was because there wasn't a whole lot of, I don't know, information that WFG had. So the hope was, well, let's kind of do it before they have the information that they need, and then maybe we can dismiss it. And so that's what we're going to be looking at today, kind of get you up to date with where we're at. And then the judge's motion on that. And it wasn't even entirely motion. I thought the judge would actually do some kind of response to it, but it was actually even more simple than that. So let's look into that particular document. So we move over to this one. Okay, so this is going to be the motion to dismiss. And this should be a good insight to some of the arguments that they have on Eric's side about why he left, why WFG was wrong. And so we're hoping that they'll kind of get into a little bit of that. And then we'll look at what the judge has to say about it. All right, so let's get into it. And I'm going to mark this. Sorry for the pause. I gotta mark that. Okay, so we're getting into this actual filing of the dismissal. So to all parties and their counsel, what they were hoping to do was on April 4th at 9 a.m. they wanted to have a hearing with the judge in order to be able to dismiss, and this is their motion on why they feel that way. They did a nice job with the table of contents. This is always helpful because you can get a great understanding of what's going on. We're going to go through a little bit of background. I don't want to spend too much time here because a lot of them have been referring back to some of these things, so we'll kind of go through that fast. But these documents are available if you want them. I did have to put them behind a firewall, so you do have to become a member. I apologize about that, but we had people doing weird stuff with them. And so I kind of wanted to try to limit that as much as possible. So we'll go through that. We'll go through what their argument is. This goes into what that WFG's contract violates this California's statute of 16600. So we'll see a little bit of what that is. You guys can kind of decide if they voided that or not. They'll go through their different complaints on that. And then that they're saying that they don't have sufficient information for each of these as far as the tortious interference, the civil conspiracy, the claim for fraud, the breach of contract, claim for conversion, claim under unfair competition laws, and claim for unjust enrichment. So this is good. They're going to be their argument on why they feel that WFG does not have enough information to be able to move this forward. This is all site code or code of other laws that are out there. Remember, I'm not a lawyer, so I'm just kind of reading this as a normal citizen and going through it. So these are all different cases that they're going to be referring to, which means we're probably going to have to skip a lot of this because obviously they're using these cases to help the judge make a favorable decision. Say, hey, this is what other judges have done, so this is probably what you should do here. And they have a lot of codes there. All right. So introduction, remember, this is going to be the GFI's side of this, right? So the complaint filed by World Financial Group seeks to enforce restraints on the defendant, Eric and Sandra, employment agreements that violate business code of conduct in California 16600. WFG is using its unlawful contract to suppress Mr. and Mrs. Olson's, intimidate thousands of victims in California, and throttle their competition because WFG is asking this court to enforce a void contract. Each of its claims lacks merit and should be dismissed. Mr. Olson, this is going back into his background, so we're going to skip some of this stuff. We'll kind of give you a little bit of it. But basically, he left San Jose State at the age of 21. He started working with WFG to sell life insurance. The multi-level marketing aspect of that pays commissions to each agent, product they sell, products sold by people whom they recruit. They reap the bounty from that business that he's built. He's over 20,000 licensed agents. WFG and the people above him have made lots of money. Now, again, if you remember, and this is what we've been hoping to see evidence about, is that Mr. Olson said that he could no longer tolerate working at WFG. So his side of the argument is that WFG has been doing wrong things and that's why he's leaving to go start GFI. And this was my hope from the beginning, that he was going to come out and have some explanation about that, of what is it that's going on behind the scenes of WFG that people can't see. And so I haven't seen him go into that, so I'm hoping that at some point we get to see some of those complaints. The only ones that we saw were kind of from Cofield, but those all came out to not be true. So I'm wondering what it is that they actually have. And so now he's saying that in his attempt to exit, WFG stopped him. He first tried to transfer his hierarchy to his wife, Miss Olson, under the Heritage Program. But when he told WFG of his plan, WFG purported to cancel the spousal transfer. So what would be interesting is if they have any information of what was actually said in this meeting. I'm assuming he sat down with WFG and said, hey, I don't know what exactly he explained. Did he say, hey, I want to start another company, and so I'm going to transfer this to my wife? But them knowing Eric Olson's perfected the anchor leg strategy, well, of course, I could see why they would say, well, we don't really want you to do that. If you're going to go start a competing company and move people over, we don't want you to be able to straddle the fence on both sides. So from WFG's standpoint, I can kind of see that, but I can also kind of see it from Eric Olson's standpoint. He goes, well, I'm kind of stuck here. What do I do? And that they didn't allow him to be able to do that transfer. And then he sought to sell his business at WFG, as many of his predecessors had done, including Rob Day, who had sold Mr. Olson's part of his book for $5 million in 2020. But Olson told WFG of his plan. WFG eliminated that program too, after it became clear that Mr. Olson would not stay under any conditions. So I'm assuming in this meeting, since it says here that Mr. Olson was not going to stay under any conditions. So it sounds like the disagreement was Olson wanted to keep his income with WFG, obviously, but then also go start another company. And that's where we get into the agent agreement around, okay, who's right and who's wrong, the non-solicitation versus a non-compete clause, and that's kind of where the argument is happening. So WFG fired him for allegedly breaching the restrictive covenants of his contract. WFG then took over his income stream. Mr. Day resumed getting payments from the very business that he had sold Mr. Olson for $5 million. So in here, it's kind of interesting, right? Because he was fired for cause. If you remember, we were looking at the NDAs from Cofield, and I have that in the members area if you want to see that too. But that was all the way back to October-ish, maybe even September, that they were doing NDAs for people. So it seems like they already had this plan in place. And if you remember when Sandra actually filed the motions to start GFI, it was long before the January termination date. And they were at like 4,000 agents in their first month, or maybe 5 weeks or so from actually being open. So it seems like obviously WFG knew there was an exodus of people. When you have people like Paul Hart leaving and Bayona, and you're seeing all this stuff, and people are seeing what they had on social media as far as the top agents moving over, and that whole kind of campaign that GFI was putting on, I'm sure that alluded to WFG of what was happening. And so at that point, they terminate the code number to figure out what's going on at that point, because that keeps him from having access to all of that stuff inside of WFG's system. So there's a difference between them stopping this for an individual, like not allowing him to do it, and not allowing all WFG agents to do it, which I don't think is what actually happened. I think what actually happened was they got an idea of what Eric wanted to do, and so they stopped it specifically for him. And so when WFG filed the instant case with Mr. and Mrs. Olson for violating restrictive covenants in their contracts, it then separately sued Ms. Olson's business, GFI, in Wyoming, making identical claims at the same time. WFG then began threatening people who worked for Mr. Olson with lawsuits under the same restrictive covenants to shill any hope of ever escaping WFG. And again, this kind of brings up the argument. And I kind of relate it to marriage, and obviously it's not the same thing, but some people were saying in the comments, they're like, well, you don't own people. Well, that's true. In a marriage, you also don't own somebody, but you make a covenant with them. And so there's a difference between getting a divorce and then having another person, right? Another spouse, another woman, right? And then there's a difference between still being in the marriage and having another woman. And those are two very different topics, almost identical in what's happening, but the way the contract is broken is kind of what's important. And I think that's WFG's side of it. It's like, we were still married and you were then cheating. That's probably a terrible analogy, but you guys kind of understand what I'm saying. Whereas WFG is saying, well, if you would have just terminated your contract, then you can go do what you want to do, but you don't be married to me and then have another woman. And that's kind of where all of this debate is happening, and the argument is. But what Olson is saying is that, well, that's not fair because under the California Code 16600, WFG breach of contract claim therefore fails in the matter of law. So he's basically saying that our marriage agreement didn't count because according to California, you're allowed to cheat and there's no obligations to that, is kind of the analogy. More so it's a non-compete clause that they're kind of arguing over. And so he's not denying that he did any of it. He's just saying that he should be allowed to do it because according to California, that's okay. Apparently you can do anything in California. So, and even if any of those covenants could be enforceable, WFG fails to allege facts that could presumably demonstrate a breach of these covenants. There are no allegations that identify how or what confidential information Mr. and Mrs. Olsons are alleged to having. No statements as to how or what allegedly they said disparaging about WFG. WFG other claims fails for the same reason. They are improperly pleaded, and most depend on WFG being able to enforce an unlawful contract. Its claim for tortious interference lacks any identifiable independently wrong act. The civil conspiracy claim lacks any allegation of any underlying tort. The fraud claim is not pled with any particularity. The conversion claim is preempted by California's Uniform Trade Secrets Act. The unfair competition claim is entirely dependent on WFG and others' insufficient claims, and the unjust enrichment claim is not independent cause of action in any of the events, is also preempted by CUTUS, which is going to be this California Uniform Trade Secrets Act. For each of these reasons, WFG's complaint should be dismissed. So they're going to go back through the background. We've gone through that multiple times. They talk about the non-solicitation. This is where most of the argument is happening around, because they're trying to say that a non-solicitation is the same as a non-compete, and those two are entirely different according to the law. Non-solicitation means that I can't go back to my or Eric can't go back to his agents and he can't go back to his clients in WFG. That's soliciting, right? He can't solicit people to come over who he previously worked with, and that's a 2-year waiting period. A non-compete means you can't operate in the same form of business. Means he wouldn't be able to use his insurance license. He wouldn't be able to recruit people. So two entirely different standards. The non-compete is way up here. The non-solicitation is down here. It's basically just don't take from WFG. Non-compete is you can't do anything in the industry. So very, very different. Okay, the confidentiality provision. Agents will not disseminate or reveal, other than behalf on WFG, the product providers, confidential information, trade secrets of WFG or product providers. Agent has therefore receives. Agent agrees that immediately upon termination of this agreement, agent will return all documents, files, lists containing confidential information. And what we're finding is the confidential information, possibly, because what was in the last filing when they updated it, again, was that they were downloading their old clients' information to bring those over to GFI. So that would be constituted under confidential information, because you should have that if you're a WFG agent, but if you're moving over, you're not supposed to have that. So where a lot of the argument comes in is when you're double dipping. So don't be married and have a mistress is basically what they're fighting over. So if you want to leave, that's fine. Get rid of, terminate with WFG and then move over. But you're not really supposed to take that stuff with you. That becomes confidential information. Any other trade secrets of WFG that has been copied or duplicated. Non-disparaging provision. Basically, you should not do anything that damages the good business name, reputation of WFG, companies, or other respective officers, directors, and employees. And that makes sense, right? Because if WFG is doing something wrong, the way that you handle that is in the court of law. So that's what I think a lot of people were expecting to see, and has been a lot of the verbiage around GFI was, okay, what is going on behind the scenes that we can't see? And I haven't seen anything really come out with that. So Eric Olson makes hundreds of millions of dollars with WFG. It's kind of a repeat. He builds his business and tries to sell it. They won't let him do it. Sandra leaves in October 4th of 2023, which is close to when Cofield's NDAs started happening as well, when he was having people sign NDAs, when he was talking to them about moving over to another business. So that kind of is in line with why Eric was probably terminated, because they probably realized that these things were happening as people were reporting it. After leaving WFG, Olson started a new company to sell insurance products, GFI. She is the sole member of an LLC. To get started, she hired Matthew Welsh, an industry expert who had not been... Okay, I didn't know that. So they actually hired Welsh, I don't know, as like an independent contractor, or somebody to kind of come in and help the business develop the structure of GFI, created original curriculum, materials, presentations, and started recruiting agents. Oh, okay, interesting. So I didn't realize that was Welsh's role. So if any of you guys know Welsh, I thought I liked the guy. That was kind of cool. He seems like he's pretty good at the business. And so basically he was creating all this stuff for GFI. So the question there too, I think, wasn't his wife still with WFG while all of this was happening as well? And then on January 10th, Mr. Welsh held a company interview meeting over Zoom, and Mr. Olson is not alleged to have attended. So the argument here, which they came out in the testimony in the last document that we read, was that Olson knew that he wasn't allowed to be on camera because he was kind of on both sides of the fence, right? He was married and he had the mistress. And so he wasn't allowed to be on camera with the mistress because he was still married. So because of that happening, it was the testimony of one of the guys last time who was saying Eric Olson knew this, and that's why he hasn't been on any of the meetings. Because part of what Welsh and Cofield were saying was, well, I've been recruiting people from WFG, but I wasn't told to do it from GFI, so it's not their fault, because Olson and Sandra are kind of off screen. Maybe they're like just off to the side so you can't see them, and they're kind of running everything, but they're saying, oh, we did it on our own discretion. It wasn't GFI that told us to do that, and that's kind of in question, because obviously they benefit from it as well. Now they're saying that when WFG terminated Eric Olson, they're stealing his multi-million-dollar business. So the question here becomes, can you stay with one company, start another company, move agents and clients over, and still expect to not get terminated? I think that's kind of a far stretch. That's definitely a breach of contract, but what they're saying is that he hasn't broken any of the rules with WFG, and that contract should not be enforced. And even if it should be enforced, because of California law, it shouldn't matter anyway. All of that should kind of just be thrown to the side. So WFG supposedly offered him a $20 million a year per year contract to stay, which he refused on January 22nd. And I think his termination date was on the 25th. So that was just a couple days before that. So obviously they were working with him to try to figure out some solutions. And so the question there becomes, was he just putting all of this off so that he could continue to raid WFG while he had no intention of staying anyway? WFG informed Mr. Olson that he was terminated for cause as a result of this decision, and you can find that video too. I have a video just about that. The people who decided to terminate Mr. Olson, including Mr. Day, are now beneficiaries of revenues of over 900 insurance agents. So it's weird here. So why is it 900 insurance agents, but then when they talk about his business previously, it's 20,000? There's a big difference there. I don't understand why the difference. Maybe it's licensed versus unlicensed, but those ratios don't work out to me. I don't get it. But anyway, on January 25th, WFG filed this action in state court together with a request for a temporary restraining order. Ms. Olson and her company, GFI, sued WFG in the Northern District of California. On the 26th, the defendants removed this action herein. The same day, Olson sued WFG in the Northern District of California for violations of unfair competition law, tortious interference, conversion, breach of contract, covenant of good faith, and failed dealings of declaratory relief. So all of these are kind of happening simultaneously, but what has happened is those other court cases are basically waiting for this one. So a bunch of things were happening in different areas, and they said, okay, let's just deal with it in California, and then the other ones are waiting basically for the response on that. All three cases have been related and are now pending before this court. Sorry, exactly what I said. So those ones are, since they're related, they're kind of just grouping them all together and working on it in one area versus relitigating things in multiple places. That would just not be very effective. So WFG filed a lawsuit against GFI in Wyoming, along with a virtually identical temporary restraining order. Some case law here. Oh, they're going back and talking about that case. On January 29th, GFI filed an opposition to the temporary restraining order in Wyoming. And part of the interesting thing with them doing it in Wyoming is apparently in that state, you don't have to disclose all of the people who are part of the business. So whoever the venture capitalist is, whoever's helping them with this, they don't have to be disclosed. You can keep that under file. And so that's part of what WFG wants to find out is who's funding all of this, who's really behind it, because it takes millions of dollars to go through these lawsuits. Arguing, among other things, that the Wyoming case is foreclosed by Rule of 13, bar of compulsory counterclaims, the first to file rule, and the doctrine of claim splitting. The district court in Wyoming has stayed that case, citing its first to file rule. So basically in Wyoming, which been maybe another reason why they did it there, I don't know, but first to file rule, so apparently whoever files first is kind of how they start to see it out, and then they'll work it through the case that way. And it's stayed, which basically just means, if you think like telling a dog to stay, right? It's waiting. So it's just sitting there waiting for this California one to go through so that then they can go back to the Wyoming one if necessary, or potentially just take up the ruling from California, okay? So to survive a motion to dismiss, a complaint must contain sufficient factual matter to state a claim to relief is plausible on its face. So they're going to go through a whole bunch of case law here and talk about why this should all be dismissed. California law applies to this dispute. Federal court sitting in diversity ordinarily follows most of the choice of law rules of the state, and they're going to do a bunch of cite code here. California's choice law is based on principles stated in the restatement conflict of laws. They're using a bunch of cite code there. WFG seeks to circumvent California law in its breach of contract claim by including a Georgia choice of law provision in its agreement. So different states handle things differently, so you can't necessarily take a law from one state and apply it to another state, which is what they're saying that they're trying to do. Since WFG is rooted in Georgia, I think they're trying to apply some law in Georgia, saying that because that's where we're headquartered. So how does that apply? But in California, parties seeking to enforce a choice of law clause must demonstrate that the chosen state has substantial relationship to the parties or their transactions, or that a reasonable basis otherwise exists for choice law. Foreign law may not apply. The chosen law is contrary to fundamental policy of California. So, and that's why, because in the state of Georgia, they're saying it's a totally different law than it is in California, so they're saying that it shouldn't apply there. And the reason why they're so focused on that California law is I think they're the only one that has one of those non-solicitation laws, or at least that's where they live, so they're kind of trying to get under the umbrella of that if they can as much as possible. So as a materially greater interest in the determination of this particular issue is California, so that's why we're doing it in California, so let's use California law, because obviously that favors them. There's no substantial relationship between the parties in Georgia, nor any other basis to apply Georgia law, so they want all of that dismissed. Application of Georgia law would be contrary to fundamental policy in California. California has more interest, so because they live in California, they want the California law to apply. They're talking about some other laws that have happened, or other cases that have happened similarly, so they're referring to those. Perfect. Okay, so let's get down to the breach of contract. So this is what they're saying, that they should not, there was not a breach of contract, or that it should be dismissed on these grounds. So WFG has failed to plead a legally factual viable claim for a breach of contract against the Olsons. Its claims rest on enforcing a contract that violates California law. So again, they're going back to yes, I cheated. I had my wife and I had my girlfriend, but I'm allowed to cheat because according to California law, you can do that. So that's kind of where they're debating it. WFG's non-solicitation clause on its face is invalid post-termination restraint. Its confidentiality clause is even broader, extending to the non-compete restrictions without any temporary or graphic limitations. So in California, you can't have a non-compete, but you can't have a non-solicitation. So what Olson's team is trying to do is kind of blur the lines between the two and say, well, a non-solicitation is basically a non-compete. Even though they're different levels of standards, they're saying, well, they're so close that we should kind of lump them in together, because obviously that helps them out. If they can get under the umbrella of a non-compete, a non-solicitation, well, then this whole case would kind of be void in that aspect of it. And they're saying that it's a vague provision that will cover any form of competition and thus void for the same reasons. If you remember, they were saying that because of the non-solicitation clause, the Olsons cannot operate business. They're not allowed to sell insurance products. They're not allowed to recruit people. But again, that's a non-solicitation clause, not a that's a non-solicitation clause, not a non-compete clause. But they're trying to blur the lines between the two of those. And instead blocks departing employees from engaging in future competition because these provisions are void. WFG's contract claims are false. So I guess that's a question to you guys. Do you feel that a non-compete obviously says you can't work in the industry at all, but is a solicitation not being able to go back and recruit old agents and move clients over, does that keep you from engaging in any kind of future competition? I would kind of disagree with that, because you can still do insurance, you can still compete against WFG. I mean, we've had tons of agents that move over to other companies, move around. I mean, that's part of the industry. People will try one company, move somewhere else. So that's not keeping you from competing. You're just not supposed to take clients or agents with you. So under any California law, any contract that prohibits a person from engaging in lawful profession, trade, or business of any kind to that extent is void. So that's the code that they keep referring to. So anytime you see that, the 16600, this is what they're referring to. So your guys' judgment on this: is a non-solicitation the same as a contract that inhibits a person from engaging in a lawful profession, trade, or business of any kind to that extent is void? I don't know. So in 2008, the California Supreme Court affirmed that the broad reach includes any restrictions on employment mobility against individuals who enter employment contracts. They're going to go through some case law on that. They talked about Edwards, which is a similar case. In seeking to bar solicitation and recruitment, WFG's post-term contractual restraints fall squarely within the conduct prohibited in 16600 of California for the reasons stated in opposition to WFG's motions for the temporary restraining order against Mr. and Mrs. Olson, all of which are incorporated inside of California. The contract WFG seeks to enforce is between a company and its since departed worker. In all ways, this is precisely the type of relationship covered under Edwards. Because if you remember, Edwards is about an employee, and this is where we get into another argument about employee versus independent contractor. So the way those things are handled are very, very different. And so they're trying to also relate being more to an employee than being an independent contractor. An independent contractor has more choices, obviously, than an employee does. Mr. and Mrs. Olsons were independent contractors, makes no difference. So they're saying even though you're an independent contractor, you are technically an employee, I guess is kind of the argument. Again, they're trying to blur those lines there, because the closer they can get to being to an employee, basically they want that hierarchical structure to look like WFG and them versus it being like this. Because if it's like this, they're two independent businesses that get to make decisions of their own. They come together, make a contract, all of that's legal. But if it looks like this, then that's where, okay, you're inhibiting them from doing any other type of business or competing against you because you have the authority and they're underneath you as an employee would be. So holding to void, so they're applied to holding void non-solicitation and non-complete clauses in both direct employment and independent contractor relationships. So Olson's claim is that both of those are not allowed. So whether you're an employee or an independent contractor, you're not allowed to hold non-solicitation or non-compete clauses. And again, blurring those lines, but they're clearly separate because they list them separately. And so here's some case law about that. Okay, because contractual restrictions that restrain a worker from engaging in lawful profession per se under the section 16000, WFG's first cause of action for the breach of agreement falls into this. So basically that they shouldn't be able to restrict them from soliciting agents or clients because that restricts them in their ability to engage in a lawful profession. I don't know. I guess you can claim that. I don't know. They're saying that it's void on its face, and they're going to go into more case law here. We're going to skip a bunch of that. Section 2.15 is virtually identical to the provision provided by the Court of Appeals in this healthcare, AMN healthcare, which stated for a period of 1 year, 18 months after the termination of employee relationship, the company employee shall not directly or indirectly solicit or induce or cause others to solicit or induce any employee of the company and company affiliated to leave the service of the company or such company affiliate. Which somebody else put that in the comments too. They said, well, you know, in corporate America, we exchange people all the time. This is a common thing that happens, especially in the tech world. And although I agree with that, there's a matter of how it's done. Usually you're fired from one company and then you move over to another company. And that's, you're still going to have relationships. They're still going to ask you what's going on. Why did you move over? Whatever. You can do that. Where that becomes blurred is when you're with one company using the anchor leg strategy is what messes all of this up. Had you just terminated and gone, there's not a whole lot that they can do. And then these restrictions are kind of up to the court to determine what's going on. But when you're using the anchor leg strategy, you're basically employed by two companies and you're moving stuff in between. And that's where it gets very fishy for the eyes of the government to see, because it's not just that you left, but you're anchoring between the two of those so that you have the intent of moving stuff over. So because this is basically saying after you're terminated, well, then you shouldn't go back and solicit or induce anybody else. Okay, fine. But the challenge that WFG is having with GFI is they're literally working in both companies at the same time. So they haven't even terminated themselves or requested to be terminated. They're acting in both, and I don't know if that's necessarily in good faith or not. So the facts of this showing why 2.15 is particularly egregious applies to Mr. Olson, and therefore restricting the healthcare argued non-solicitation prevented its former recruits whose jobs in A&M consider recruiting travel nurses on 13 weeks. Okay, and if you remember, I don't know if this was during COVID or not. I don't know if there's a date on that, but travel nurses get recruited all over the place all the time. So a little bit different situation because you work your contract for 13 weeks, right? So not that long, 4 months, basically 3 months, and then you would get recruited into another hospital, which would then hire you for a short period of time. So you're doing short stints. So of course you're jumping around all the time. And so a little bit different than when you're talking about an agent that's contracted with WFG, that's a little bit different. So yeah, of course, if you're a recruiter and you have a relationship with somebody and their contract ends, you're going to talk to them for another contract that opens. That kind of makes sense, but they're trying to say that those two pertain to the same thing as what's happening with Olson and moving people from one company to another company. All right. Soliciting travel nurses to take assignment with their new employer. Similarly here, Mr. Olson has developed his career recruited over the course of 20 years, yet according to Mr. Olson, should not be allowed to engage in any recruiting. So again, your guys' determination, do you think that non-solicitation clause of you can't go back and recruit WFG agents prevents him from any recruiting? Because that's a much higher standard than just not being able to recruit people currently in WFG. It doesn't mean he also couldn't recruit people who were formerly in WFG and had quit or moved on to another company or whatever it might be. It's just saying they're trying to relate it that he can't do any recruiting whatsoever because of this non-solicitation clause. The agent agreement repeatedly explains that downline agents of whom the agents are recruits, are part of the compensation structure for the job. For example, an agent agreement states that the compensation paid to an agent is compensation for his or her downline sale or referring to products and services. Yeah, so any time of broker-agent relationship, there's an override there, right? And so part of the broker's contract, even if you look in real estate, the broker gets a part of those agents' deals whenever they sell a home. So same exact thing. So basically what he's saying here is under the agent's composition, it further explains that the agent is compensated under the agreement only from the sale or referral of the products and services offered through WFG by the agent or the agent's downline. So there's your personal production. You can sell a home, you can sell an insurance product, or you can override your agency, which does all of that. Which, fair point, right? Because one of the Experior guys was hopping in saying, well, you know, he could take all of that with him. You own your book of business. But I think probably 98% of Eric Olson's business is going to be from his agency. It's not his personal pen. I mean, I would doubt you're making $1 million a month because you're great at writing insurance policies. It probably has a lot to do because you have a big team of 20,000 agents and you're making a little bit off of that entire hierarchy, right? So the question then becomes in that ownership, which a lot of WFG people and outside the Experior guys are like, well, what's your ownership? What do you actually own? Do you own the agents that work under you? Because they have they have the ability to pick where they want to go as well, right? Whether they want to stay, whether they want to move their clients over. So all of that becomes a big question as far as ownership goes. And then the other option, you see a lot of the guys come in and say, well, you have complete ownership here. Yeah, but you don't have any type of hierarchical structure. So you've basically got to go do everything on your own. You can recruit a couple people, but if somebody wants the same contract as you, well, then they just leave your agency altogether and go start something else. So that's the challenge a lot of real estate agents have, is you train up this guy, they become great, but then they leave and they go start Century 22 next to your Century 21, and you get no override of that. Some companies like Farmers or State Farm, sometimes they'll give you like a little bonus when a guy goes and does that and opens up his own agency that comes from your inside, but it's maybe $3,000, $4,000, $5,000. When instead Eric, that's where most of his money is being made, is because he develops people, and that's kind of, you can't even argue that, right? Like, he's a great leader at what he does, so that's where most of his income comes from. It's not from being his personal pen. So important to understand there that if he leaves to another company, what he's saying is that he's leaving his income behind because he's leaving those people. But isn't that kind of what you agree to? And this comes the question of who reads their contracts. Because obviously you don't own the people in WFG. They have their own autonomy. They can decide what they want to do. So anyway, Section 2.16 is even broader than 2.15 and is void for the same reasons. It talks about confidential information is broadly defined to include any and all personally identifiable information, confidential and proprietary records, information created by or on behalf of belonging to WFG, as well as list WFG agents, including their identities and contract information. So again, you're not supposed to take that stuff with you. They're saying that it's too broad and therefore it should be not allowed. Courts have repeatedly struck down similar clauses where an agreement prohibits using confidential information to solicit work and then defines confidential information in a way that prohibits competition. So that's a fair point, and I think the question here becomes, in confidential information, if they use the same exact structure, is that considered confidential information? Especially, a lot of you guys have put in the chats, what is it? I think it's PFA, PHP, now GFI, HGI, I don't know, probably 5 or 6 other companies have all used basically the same structure from WFG. They're all spin-offs of very similar structure, and even WFG is a spin-off of Primerica. So is that still considered confidential information just because it's a hierarchical structure? If everybody is using it, I don't know if that becomes confidential information at that point. But so they're saying that it's way overbroad, this information to restrain trade, which, fair point, if the structure is not allowed, and obviously they changed some things, and maybe that's why. Maybe if there's enough change, it's not confidential information anymore. but that seems a little bit tough to kind of rest on. So not only does WFG define confidential information to include information that agents obviously would have, as in this particular case, it defines and encompasses lists of WFG agents, including their identities, contact information, which factually bars competition. So again, question for you guys. Are you barred from competition if you're not allowed to take all of the contact information from your agents and your clients with your former company? I don't know if that stops you from doing business in the future. It just stops you from moving those particular people over. But since he's saying that's part of his income, question is, does he get to take that with him? WFG concedes that some of the agents in Mr. Olson's hierarchy are family members, so it becomes an interesting question too, right? Because we recruit a lot of friends and family. So what happens in that situation? Again, if you were to terminate, though, those people can still come over with you. It's just how you solicit them. And I don't know, maybe you guys will know if WFG has sued people for family members coming over. Not that I know of, but who knows? I don't get to see any of that stuff. So within the scope of the clause, so can you recruit your family members and friends over? I think that's kind of, again, trying to blur the line between he's got a couple friends and family members and he's got 19,000 other agents that are not friends and family. And so do we lump all of those in together? I don't know. But then they're going to go through some case law on that. WFG's employment agreement suffers from the same problem. The confidentiality language has no temporal graphic limitation. The use of confidential information prevent Olson from soliciting employees in perpetuity, and separately prohibits use of trade secrets to the same end. I don't know if it does it into perpetuity. It's just for those 2 years or 18 months, but obviously he's trying to blur the lines there too, and saying that he's not able to solicit any employees forever, and separately prohibits that. So more case law. I'm going to kind of run through that. And because of a core feature of both WFG and Mr. Olson's profession and his ability to recruit agents to sell insurance, these overly restrictive provisions operate as a de facto non-compete provision. So again, they're saying if you can't take your agents with you, well, then that is considered a non-compete. Kind of a question for your guys' interpretation there. Overbroad confidentiality provisions, such as WFG's alone, unreasonably restrictive and void that section 16600, sweeping definition of confidential information, more case law. Section 2.17 is unforceable restraint, which is interesting because if you guys remember, we went through GFI's case, or GFI's agent agreement, and it's almost identical to what you would see in just about everybody's, and it has all of these things in it. It says that you're not allowed to take agents and clients with you. It says that you're not allowed to take confidential information with you. It says that you're not able to do anything that will damage the business as you leave. So it's weird that he has those exact things, maybe because it's not in California, but he lives in California. So he has those same exact things. If you go to GFI, you're under these same exact restraints. But here he's claiming that they shouldn't be allowed. So I guess it opens up the door for future GFI agents that if Eric did win all of this and they said that you're not allowed to enforce those things, well, then you can do whatever you want in his contract because that he was able to do the same thing. So keep an eye out for that. That'll be interesting. That for his sake in the long run, he probably doesn't want these things to go through because he wants to be able to enforce them with his company. Separately imposes a one-way restraint on Mr. Olson that prevents him from making any statements about WFG that could be construed as negative regardless of the truth. So that opens up a question as well. If you know of something that happened, because you have inside information, right? You're on the leaders board, or you get into those type of conversations, and there's something negative that happens and you don't like the way that that's handled, is that still considered disparaging statements if it's true? Now, I think that gets into an entirely different lawsuit because you can probably defend that and say, well, this is what actually happened. I was just telling the truth. But here they're kind of relating those two, that disparagement requires a false and misleading statement. So a non-disparagement clause would likely violate this as well. So again, all of these are hinging on this California statute 16600. And so he's hoping that that gets rid of all of these things, which makes it his contract with GFI basically void as well. So I don't know if that would necessarily be a good thing for him in the long run. He would also be barred from highlighting positive aspects of a new business as compared to his competitors. Fair point. So if you say, well, mine is better, GFI is better here for the new agent because we have a higher initial contract, is that a disparaging statement against WFG? I think that's kind of, I don't know, I think you're splitting hairs at that point, but fair point, because it could be construed as a disparaging aspect of WFG. And not every company is perfect. No company is perfect, I should say. So part of what I've got set up to do is I've got a guy who I met, Khalib, through all of this. And so we've been talking a lot about different compensations and ownership and everything else. So if you guys want to see that on Friday, we're going to be going through and basically doing a drill down, kind of if you've ever seen where companies are the best at. Because most of them do a company A versus company B, PHP versus WFG, or Primerica versus this company, whatever. We're going to take 9 different companies and break them all down and say this is where each one's strong, this is where they're a little bit weaker, and in each section you'll be able to kind of figure out how that relates to you and how you want to run your business. So WFG might be stronger here, GFI might be stronger there, and depending on who you are and how you want to run your business, it might help you make a decision on which company to go with, because there's so many of them out there. Some of these I didn't even know, but apparently he's worked with a bunch of them and knows the leadership of a bunch of them. So I think that might be useful for you guys if you want to check that out. And we'll kind of go through, how do you even decide? Because if there's 8 or 9 companies that do almost the same thing, how do you decide? Because if you're comparing 2, it's easy to cherry pick and you go, okay, well, WFG's starting contract is lower, so that's why you should go to GFI, but the dollar can only go so many places. So if you're getting more up front, it usually means you're getting less in the back end, right? So, because you can't split $1 more than $1. So how it gets paid out is different. So I think all of that's going to be kind of useful information as well. So hopefully you check that out on Friday. But anyway, WFG's contract is void and cannot be reformed. Again, it's overbroad, unlawful restriction. WFG's contract cannot be construed narrowly or otherwise fixed. So this is all breaking down more case law about non-competes. The court also has no reason to engage in narrowing exercise here. So what they're saying is, court, we don't want you to come in and help them narrow this down. We just want it gone altogether. Don't help us with this aspect of it and saying, well, you could do this, but you can't do that. Let's just throw it all out to the extent that WFG claims the restrictive contract is necessarily to protect proprietary business information. It already has effective remedies under California statutory common law, including the California Uniform Trade Secrets Act. And so don't help us with narrowing these things down. Just throw it out and let them figure it out for the future on what they want to do, because we don't want to be restrained by any of it, obviously. So it protects the personal information of clients. The contract does nothing to add to this protection. Rather, it's collectively collection of restrictive covenants significantly hinders employees' mobility and chills potential competition of both. This as enacted to stop because its contract is void on its face. WFG's contract claim should be dismissed without leaving to amendment. So just dismiss it. Don't amend it. Don't change it. Don't say, here's what you can do and what you can't do. Just flat out dismiss it. We don't want any amendments. We don't want to say this is okay and that's not okay. We don't want you to divide the line, do the Franklin Templeton, right? Pros and cons. No, you're just going to flat out dismiss. Okay. WFG fails to plead significant facts to establish breach of contract. So separately claims that WFG fails to plead the contract state of plausible. First, WFG alleges the misuse of confidential information, naming it its hierarchy, compensation structure, insurance list, performance of agents, and other specific non-public customer information. So the 2 big here for me that stand out the most that it looks like they're doing specifically is the targeting of insurance agents and the targeting of customers. And I guess they're classifying those under confidential information, and that's what they're arguing about here. So for example, WFG's vague allegation that the Olsons used information about WFG's business structure. Again, should that be confidential information? I don't know. But I think what they're referring to is the hierarchy structure. So in the company, you can go in and see your hierarchy, right? So you could download the sheet of who's the top performers, and then you go solicit those agents, and you can also see who's in those other agencies. So let's say for Welsh's organization or for Cofield, you could see them as running the agency, but you can also see inside that agency. So if this person says, no, I don't want to go, well, you go to their top producers, you then convince them to come over, then you go back to that agent, this is what we're seeing is happening, and then you get them to move over because they're going to lose all of their business. So this again gets into ownership. If somebody wants to stay and you can go in there and take all of the people from under them, well, now they kind of have to leave. And that's part of the claim that we saw in the last filing, was the person who went over to GFI because they were saying they were going to take over their whole business. And then that didn't end up actually happening. So now they're coming back to WFG. And so it ends up with this whole weird, messy thing that I think a lot of it could have been avoided if we didn't do the wife and the girlfriend at the same time. Just divorce one, go start your company. And other people have done that and they've been perfectly fine with it. So having a hierarchy of business structures, intent for the structure of MLM, even if WFG's hierarchy business structure were somehow confidential. The complaint does not offer any specific allegations. It just refers to hierarchy, business structure. At most, it makes conclusory allegations that the business model, including its hierarchy structure, was nearly identical to WFG. WFG allegations that the Olsons have used confidential information, compensation structure fares no better. Compulsory allegations misused WFG's compensation information were identical to that of WFG because it's basically the same, but they all do it, so I don't know how you could necessarily fight that. Nearly identical. As far as WFG alleges, insurance agents lists are confidential information. So this is interesting too, because if you remember in the last one when they were saying that, when the Olsons were saying that we don't want WFG out of discovery because the confidential information agent lists are confidential. But now when it's the other side asking, when they want information, it's no longer confidential. So if GFI wants it, it's not confidential. If GFI wants it, or if WFG wants it, it's confidential. So that's kind of what they're fighting here, and they're saying that in these particular cases, that the secret for purpose of its trade secret clause of any action were already known. So they're saying that since they already know them, it's not confidential information. And more case law behind that. WFG remaining allegations are even more conclusory. That dismantles them from the preemption of truth, alleges misuse of confidential information, agent performance ranking. So again, the understanding is, or the testimony that's coming out is that they were using the performance rankings on knowing who to target. So who do we go after first? Obviously the higher ranking ones. We're going to bring them over because they're probably going to help us in this as well, which creates the question, and this is what Bosley talked about, is who's going to help with the lawsuits around all of this? And Olson basically said, well, we have an open line of money that we don't have to worry about the lawsuits. Because here's where it gets interesting for the agents that are moving over, is so if I'm told to move over, and then I move over and now I'm soliciting my agents and my clients to move over because that's what I'm being told to do, well, now they're open to the lawsuit, and so who's going to cover them? All of it helps Olson regardless, and he'll probably have to pay a fine or whatever it might be. They might even settle it out of court. But what about those lower level people who are bringing over 15 or 20, 30 agents, not nearly as big as Olson is, but now they're subject to those things as well because they're using those performance rankings to go in there and recruit without explaining what it means or how the information that was used by the Olsons, agreements with product providers without specifying which agreements were taken, or how they have used. And remember, this is all going to kind of start off broad because WFG they were trying to figure out what was going on. So you leave it a little bit broad, and then the challenge with that is the defense can then go in there and say, well, this is too broad. And so part of this in their refiling and what they just refiled is that they're getting narrower on these things. They're figuring these things out as they go through. So we're going to see both of these arguments kind of whittled down into what the actual arguments are. Secondly, WFG fails to allege any false statements of Mr. and Mrs. Olson to induce agents to leave. They fail to allege Interesting. Okay, so they're saying that they have no evidence of Mr. and Mrs. Olson inducing other agents to leave. Okay. To state a claim for breach of contractual non-disparagement obligation, the party must allege special damages. They're going through some case law. Here, WFG has not alleged any special damages in its prayer for relief and has not identified a single agent who left WFG as a result of the Olsons' supposedly defamatory statement. That alone is fatal to this breachment. So they're so tricky with words. Man, this is why we got to get good with our words, right? Because we don't pay attention to these things. So what they're saying is who left WFG as a result of supposedly defamatory statements. So not left because I recruited them, but we have no evidence that they moved because of the defamatory statement, which is an entirely different sentence, right? If you took that out, we don't have any evidence of a single agent who left as a result of the Olsons, period, is very different than we don't know anybody who left from the Olsons making defamatory statements. So did they come over because of the Olsons, or did they come over because of the defamatory statements? And here's where they get tricky with the words. And what they actually mean. So, moreover, disparagement requires the plaintiff to point to seek specific false and misleading statements, which they've already done, and they came back and kind of went against that. So the false statements were, Thawley's going, we have all of this backing, all of these other agents are going, WFG is falling apart, stuff's happening with the leadership, all of that kind of stuff, which is what they're finding in their testimony now, are the false and misleading statements. So the complaint does not explain what disparagement means. So that's where we get into the definition issues. Olson and his co-conspirators continue to spread lies and disparage WFG, but WFG fails to identify any statements by the Olsons. The only allegations in any detail concerning the statements in this party of Mr. Olson's, WFG cannot assert breach of contract claim for disparagement on such a pleading. Given the deficient allegations, WFG's breach of contract claims fall short as being plausible. They go through some more case law here. WFG fails to state a claim for tortious interference. They have not alleged facts that can be plausibly supported from that. No legal assurance of them, and they kind of go through some more case law. Only independently wrongful acts in the complaint is the use of WFG's confidential information about its business structure, insurance agents, and their performance, hierarchical structures, and agreements with product producers to induce their colleagues to leave WFG. As discussed above, WFG's contract claim fails as a matter of law. WFG fails to state a claim for civil conspiracy. Again, they're going to be deciding under the California state law, and they're going to kind of go through this as well. WFG's civil conspiracy claims fail for similar reasons. Alone, a conspiracy does no harm and endangers no tort liability. It must be activated by the commission of an actual tort. The civil conspiracy, however, atrocious, does not give rise to a cause of action unless a civil wrong has been committed resulting in damage. WFG's complaint fails to identify specific wrongful tort that Mr. and Mrs. Olson have engaged in. WFG's fraud and conversion claim falls short of that. The lack of underlying tort is fatal to WFG's conspiracy argument. WFG fails to state a claim for fraud. WFG that could possibly support its fraud claim both under the federal rules and California laws. A party must plead fraud and with specificity. So they're citing more case law here. Here WFG's fraud claim boils down to an allegation that Olsons employed an anchor leg strategy whereby the Olsons and GFI recruited the spouse of a current agent, WFG's spouse, to join GFI while WFG insurance agent remains with WFG, at least temporarily. We did a whole video on that. You can see that in the member section as well. The anchor leg strategy was actually even more nefarious than I thought. They would even do it for promotions. So if I have somebody who's licensed in one leg and I can get their spouse or their friend, or I don't know if friend would work, but family member or spouse to get a license in another leg, then the agent writes the business, but they do it under the other person's name, so it lifts up this particular leg so that the points are going over here, which is illegal first and foremost. And then underneath that, that spouse or family member would open up a joint bank account with them. So then that person who wrote the business is getting paid for business they didn't technically write because they wrote it under the other person's name, which kind of gets into a whole nother legal issue. And so they're basically saying that that's what they're doing, and they're saying that this is just an allegation, that it didn't actually happen. And the agents who continue to work at WFG work through false premise that they are building their business for WFG. But WFG has not pleaded the speaker of any alleged false statements, nor explained how any false statements could attribute to the Olsons, much less identify a time, place, or specific content. WFG fails to state the claim for conversion. WFG's conversion claim falls for at least two reasons. First, as described above, there's no factual allegation that Mr. and Mrs. Olson took any confidential information. Second, this claim is separately precluded because it is predicated solely on the alleged taking of confidential information. So if we don't know what confidential information is, we can't then be in trouble for taking it, if that makes sense. A claim for conversion must be based on the actual interference with the plaintiff's ownership, rights, or possession. Conversion traditionally required the taking of a tangible property and thus was not available to remedy this misappropriation of something like a trade secret. So again, in the conversion, it's not tangible property, right? Because it's names and phone numbers and information about agents and clients. So they're saying it doesn't fall under that. And then it's also not a trade secret because everybody in the hierarchy has access to that information. So to establish a claim of conversion, the plaintiff must show 1, the plaintiff's ownership to right or possession of the property, the defendant's conversion by wrongful act inconsistent with the property rights of the plaintiff, and damages. So that's what they showed in that last one, which was people who were downloading or asked to download their client information from WFG to take over to GFI. And so they're going to go through some more case law here, and we're just about ready to wrap up. And conversion claims. WFG's conversion claim is based extensively on the Olsons' alleged use of WFG's confidential business information. It does not allegate that the Olsons converted anything apart from its supposed confidential information. Thus, the conversion claim fails, and the reasons provided above is separately preemptive of that former law. More case law, and fails to state a claim under the unfair competition law. Again, this is referring to the California Code 17200, that the unfair competition law prohibits any unlawful, unfair, or fraudulent business act or practice. And they're saying here that because of all WFG's other claims as a matter of law, as discussed ante, so too must this derivative UCL. So they're referring to that case law. WFG fails to state a claim for unjust enrichment. Alleged the use of WFG's confidential information. First, it should be dismissed because unjust enrichment is not a cause of action under California law, according to this particular case. Of unjust enrichment claim without leave to amend, don't amend it. Again, that's kind of the same thing. Without leave to amendment because of just enrichment. Because WFG's unjust enrichment claim is entirely derivative of UCL claim, just as the UCL claim is predicated on the Olsons' alleged use of WFG's confidential information. So more case law there, but basically, third, the enrichment claim is solely based on the Olsons' alleged misuse of WFG's confidential information. So since that hasn't been specified, that it should be it should allow them to go into and get this dismissed early. So for the foregoing reasons, WFG's complaint should be dismissed in full. Okay, and so with the previous filing that we saw, the judge came back, and what was interesting, I was waiting for an actual ruling on this, and I'll get to some comments here in a second. I appreciate your guys' patience. This was long. So what I thought the judge was actually going to have a ruling on this, but he didn't. So it was actually more simple than that, and I'll show you guys what he said here. So coming in, I was kind of waiting for this to actually have some kind of, I don't know, saying from the judge. It didn't. So apparently these two motions, number 62 and 63, that was Sandra and Eric's filing of the dismissal. You can see it up here. Oh, sorry, this is the one we just read. And then this is Sandra's version of that, which we read earlier, but it was just basically adding herself onto Eric's filing. Those were terminated, and the motion hearings were vindicated. So meaning they're not going to be allowed to dismiss. Those were terminated. So meaning it's going to go into an actual hearing. So it's not going to get dismissed in that process. So the next thing that we're going to be looking for after that amendment, which was the last video that we did, so you can go watch that, and that updated all of these things. It was a response to this particular motion and them getting more clarity in each of those points and showing why confidential information was being used, how it was being used, what the idea was with GFI agents to bring those things over, how are they going to do that, all of that. So basically we're waiting for a response from the Olsons to that particular complaint by the 14th. So that's the next thing that we're going to be looking for. So basically WFG is just going to be working behind the scenes collecting that data up until that point. And you can see up here, I didn't highlight that. So here you can see up at the top, 62 and 63 were the two filings to dismiss. And then down here was it being terminated. So 62 and 63. And I think I lost you guys there for a second, but we're back. Okay, so let's see. Sandra M. And the disparagement of the old company to their agents. Yeah. Thank you, Mckensy, for putting the facts out. You're welcome. That's Herson, I think is how it's pronounced. This would have all worked out well if he just went about. Yeah, that's my point too, TMM. I appreciate you putting that out there. You can go about it in the right way, right? And that doesn't seem like what actually happened, unfortunately. So you can get divorced and then go get another girlfriend. You might be mad at you for the divorce, right? But you can do that. What you can't do is have two at the same, or what you're not supposed to do at the same time. Doesn't want to work for WFG. He wants to be WFG. Sounds like PHP playbook. Jeremy, I don't know what that means. I apologize. I don't know what you're talking about there. Okay. To my knowledge, WFG offered Ed an agency chairman position that paid several times what he was making at the end. Ed didn't try to continue to receive compensation while creating. Yeah, that's a good point, Jeremy. Ed didn't compete, right? So he didn't go out and do other stuff. Which is kind of the difference there, I guess, is what you're trying to say. Sounds like the girlfriend looks a lot like the wife. Sounds like the girlfriend looks a lot like the wife. Yeah, exactly. He duplicated them. So is the plan to trade the girlfriend for Bill? I don't know what that is. Hence the NDAs. Yep. So that's what the NDAs were for. So anyway, special shout out to our some of our we had some people become members as well. So I appreciate you guys, Woody, Tyler, I don't know if I'm saying that right. Adreni? Correct me if I'm wrong, but I appreciate you guys for becoming members. A bunch of you guys have asked of ways that you guys can contribute to the channel. Some of you guys said, hey, can I buy you a coffee or whatever it might be. I've gotten into, probably a couple $100 in court filing fees for downloading all of this stuff. So I appreciate you guys. There's an option if you want to do that. Please don't feel obligated by any means. But if you're getting some support from this, if this helps you, there's different options in there if you want to become a member. That also gives you access to download any of these documents. Unfortunately, I had some weirdos who were taking these documents and just completely fabricating stuff. The Life 180 guy was one of them, and so he took some of my documents of the court case. And then I love the way they always do that too, right? Like, don't join that company because they're going through whatever it is that they're going through, but come join my company and you can recruit to me because I'm better and you don't have to recruit other agents. It's like, okay, so you're okay being at the top of it, you just don't want to be at the bottom of somebody. So if you have the company, you're okay recruiting agents, and that's not multi-level marketing because you have multiple layers of agents under you. But when WFG does it, well, then it's multi-level marketing and you shouldn't go over with them. It's so funny how they do that. So they love recruiting people. They just don't like doing it in somebody else's system where they're not at the top. So anyway, if that's something you guys find value in, please look at doing that. You can just hit the join button, and I would appreciate it if you guys do that. But again, don't feel obligated. I'm going to keep putting this stuff out as much as I can, have good information, and get that to you guys. So I appreciate you. I appreciate all the feedback and comments on both sides. Some of you guys have corrected me on some things. Some of you guys have said good job. Some of you guys said you suck. I appreciate all of it. I expect all of it. And I hope you guys take care. Hope this was helpful for you. So hopefully in the next week, we'll get that filing back from the Olsons to figure out kind of what the next steps are. So I appreciate you guys. Catch you later. Bye.